With the ruling of the court, the accused person, Nuru Okanga Maloba, has been charged with 3 counts of offenses, namely publication of false information, contrary to Section 23 of the Computer Misuse and Cybercrimes Act, number 5 of 2018. Under this charge, it is the prosecution case that on diverse dates between 12th and 10th of June 2024, at a known place within the Republic of Kenya, jointly with others not before court, knowingly and unlawfully published false, defamatory and threatening information online while using the TikTok account dubbed Riba News at Riba News, Siasa TV KE Backup, and YouTube channel / Google website account dubbed Riba News at Riba News, posted a caption video to wit, Rigathi Gachagua piga Ruto risasi, knowing it to be false and well calculated to cause fear, panic among the citizens of Kenya and destroy the reputation of the executive leadership of the president. Count number 2 was publication of false information, also contrary to Section 23 of the Computer Misuse and Cybercrimes Act, number 5 of 2018. It is the prosecution's case that on 12th of June 2024, at a known place within the Republic of Kenya, jointly with others not before court, knowingly and unlawfully published defamatory and threatening information online while using TikTok account dubbed Siasa TV Backup, posted a captioned video to wit, pilot wa Ruto adungwe shindani, knowing it to be calculated to cause citizens of Kenya and destroy the reputation of the executive leadership of the Republic. Count number 3, providing telecommunication services without a license, contrary to Section 24 of the Kenya Information Act 1998. It is the prosecution's case that on diverse dates between 7th and 10th of June, at a known place within the Republic of Kenya, jointly with others not before court, while using TikTok accounts dubbed Riba News at Riba News and Siasa TV KE Backup and YouTube channel / Google website account dubbed Riba News, published videos captioned to wit, Rigathi Gachagua piga Ruto risasi and pilot wa Ruto adungwe shindani, which was in contravention with the provisions issued on the issued valid license. The prosecution called 3 witnesses. The first witness was PC Samuel Kamau, the investigating officer attached to the DCI Serious Crime Unit, who testified that on 11th of June 2024, he was assigned this case to investigate alongside Chief Inspector Kinyua. He stated that the case was initiated through Cyber Patrol and that there was no complaint made. Person, Nuru Okanga Maloba, trying to pass information to the Deputy President to look for a gun and shoot the sitting president. He also stated that they proceeded to draft a letter to the Communications Authority of Kenya requesting for extraction and preservation of the footage. He added that the said video was saved in a CD and supported and supplied to the DCI together with a report which he identified and was marked for identification as the one. From the DCI, they were able to track the suspect's location via his mobile number and prepared an inventory which was signed by the accused person. He also stated that they sought custodial orders, which they were granted 4 days for further investigation, after which they proceeded to charge the accused person. He also stated that they prepared an affidavit and sent it to Google to obtain information from other websites. He produced the following documents, which was a letter from the DCI, a report from the cybercrime unit, which was marked as for identification number 2, and a report from Communications of Kenya, which was also marked as number 3, an inventory dated in 2024 as exhibit number 4, consent to search digital data, which he also marked for identification as number 5, a miscellaneous application for case number 28 of 2024, a second miscellaneous case application for 2081 of 2024, marked for identification as number 7. He also produced an exhibit memo dated 14th of June 2024, and also marked for identification screenshot clips as number 9. In cross-examination, the said witness stated that he had not played the video for the court to see. He also stated that during the said time, there were countrywide demonstration, the aftermath of which many youths were killed. He further stated that he did not know if this case was as a result of the accused person's political expression. He also admitted that there was existence of an AI video showing people like the president. He also stated that the photo may have been manipulated with AI, and stated that he was not an expert in electronic evidence. He also stated that he was also not an expert to take caption viral. Reference was stated that he admitted confiscating a mobile phone, forensic cybercrime laboratory. He also stated the video was published by Riba News and Siasa TV KE Backup and Diff Media. He also stated that he did not know if these accounts are under the control of the accused person, and also stated that he does not think these publishers had a license for publishing. He also stated that he could not authenticate the video as he was not an expert. He also stated that he is aware the accused person is a political activist, and that he has been seeing him in such forums. He also stated that a miscellaneous application for custodial order was filed, and the accused person was placed in custody for 4 days, and also stated that during the said time, there was a nationwide demonstration which was being carried out every Monday and Thursday following the draconian finance bill. He denied that the reason for the arrest of the accused person was to bar him from participating in the said demonstration. He also concluded by stating that he was not aware the accused person was in a custody until the end of June demonstrations. In re-examination, he stated that he is not an expert in AI, and reiterated that the accused person was referring to the current sitting president. The second witness was PC Milton Mwanzi, the arresting officer attached at DCI headquarters, Serious Crime Unit. He testified that on 11th of June 2024, his in charge instructed him to accompany a team proceeding to Tasia area in Embakasi in order to arrest one Nuru Okanga Maloba, who had been seen in a certain video that was circulating in social media platform, namely TikTok. He also stated that the accused person had been captured while addressing the public, stating that the former deputy president should exercise his expertise as a former district commissioner and shoot the current president, since he's disturbing him as he used to disturb the president, the former President Uhuru, while he was the deputy president. He also stated that they monitored the accused person's movement and managed to apprehend him after he entered a barber shop and escorted him to the DCI headquarters, where he handed him over to the investigating team. He also confirmed that the accused person before court is the one he arrested, and also stated that he does not know the charges that the accused person had been charged with. In cross-examination, he stated that he did not know that he was not the complainant and that he did not know who the complainant in the case was. He also stated that his role was only to accompany the arresting team and that the accused had been seen in a trending video, but he could not confirm if the same was genuine or not. He also stated that he did not know if the accused person's mobile phone had been tracked, and also stated that he did not know and was not aware if there was a court order to that effect. He also stated that they had no such warrant or warrant of arrest, and stated that the police are allowed to. He also stated that they did not find the accused person using his mobile phone or a laptop for cyber open that account. He also stated he could not confirm the password of that TikTok account as he was not an expert. He also stated that he did not follow any illegal commands to have the accused person arrested. The third witness was the forensic analyst PC Juma Said Mwajirani from National Cyber Forensic, seconded at KSAT Communications Authority, and he stated that he gave his list of qualifications and stated that on 14th of June 2024, he received a request letter from Serious Crime dated 14th of June 2024 with a subject reference requesting information on TikTok account. He added that the second request was for a YouTube or a digital account channel and the Riba News channel Riba News. He stated that he conducted a forensic through a web, which he gave a link. Instead, he extracted the media, which had 132 likes, 11,000 views, and 22 comments. He also stated that he took a screenshot of the page and further stated that metadata showed comments from the members. He produced the said CD as exhibit number 11 and also played the video before court, which is stated was from Riba News showing the accused person addressing a media. In cross-examination, the said witness stated that he had extensive experience on use of a computer for about 2 to 3 years. He also stated that he did not know what the accused person, what charges the accused person was facing. He also stated that he did not know who authored the said digital account, and also stated that from the report he received from the DCI, the same was titled False Information and Providing Telecommunication Services Without a Valid License. He also stated that the videos are from a link and that a gadget never comes with installed TikTok account or YouTube account. He also stated that the same comes into existence after installing and that it bears the names a person owning the account puts. He also stated that the social media are under open source and that one only needs to type a name in that media and that you do not need a Gmail or a YouTube for you to access Reference was also made to a certificate of electronic evidence, and PW3 stated that the same reads, "You need TikTok account to post." He clarified that one needs, however, clarified that one needs not to have a TikTok account to access it. He also stated that the links were not stored in a computer and that they were posted by two people. He stated that he did not have information on the person that posted in River News. He also stated that there were 22 comments, and denied that he was selective in which page to take a screenshot of. He also stated that the role of the forensic analyst is to add on the investigating officer's evidence. He averred that his work may help the case of the investigating officer. He also stated that he only analyzed the video but not the metadata. He also stated that the author of the video was River News and not the accused person. He also stated that he was not aware the accused person had been charged with the publishing of the said news. In cross-examination, the said witness was referred to his forensic report, which stated that it had indicated the video was inflammatory, as the accused person had stated, "Take a gun, put in your pocket, go and hit him." He also stated that he was a member of a professional body and that he had not crammed his membership number. He also stated that he had not filed an extraction report, and also stated that the said video was from YouTube. He also stated that there was no second eye in the verification, as he was a qualified expert. He also stated that there were tools which he used and to link the said information that was extracted, and also stated that he had not provided the footprint to show the process. In further cross-examination, he stated that reference was made to his report, which indicated that the same was prepared in 2023. He corrected it and stated that it was a typo. The same ought to read 2024. He also stated that he is a member of a professional body that was registered in 2024, before the date when he made this said report. He also stated that he did not receive any gadgets from the investigating officer for analysis. He also stated that he cannot prove if the said video was doctored, and also stated that the court will make a determination if indeed his report passes the test. In further cross-examination, he stated that the comments were metadata and that the same were locked, and also stated that he could not access the whole comments. He also stated that he did an open source intelligence and that he did not do an analysis to confirm whether there was third-party manipulation. Reference was also made to the charge sheet, which referred to Siasa TV KE. He stated that his report did not cover analysis on the Siasa TV KE. In further cross-examination, he also stated that the tools which he used normally goes through updation, and that there were chances of running small errors, and that sometimes it can provide negative or false positives, but to a smaller margin. Having heard the prosecution case, is the analysis of the court to make a determination or a ruling rendered pursuant to Section 210 of the Criminal Procedure Code. In discharging this duty, the court is acutely aware that it is not called upon to make a final determination on credibility or guilt, but to consider whether the evidence placed before it discloses the essential ingredients of the offenses charged, and whether the evidence sufficiently connects to the accused person to those elements. The background of the case has been laid down, that the accused person, having been charged with the 3 counts, the law has to look at the evidence if the accused person will be found he has a case to answer or not. Therefore, in looking at the elements of the said offense, the first one was for publication. The offense under Section 23 for Computer Misuse and Cybercrime Act, the prosecution must establish the following elements. Firstly, that there was publication of information by the accused person. Secondly, that the information was false. Thirdly, that the accused person knew the information to be false or was reckless as to its truth. Fourthly, that the publication was likely to cause panic, chaos, violence, or damage to reputation. For this offense under Section 24 of the Kenya Information and Communications Act, the prosecution must establish that the accused person provided telecommunication services and that such provision was without a valid license issued by the Communications Authority of Kenya. The prosecution bears the burden of establishing each of these elements through admissible and credible evidence. The prosecution evidence in detail, according to the first witness was the investigating officer, stated that he was not an expert in determining whether the said video was real or not, and also stated that he considered the matter as a matter of public interest and thus charged the accused person. He also stated that he made a request to the Communications Authority to extract and preserve the footage that the video and the said video was saved in a CD and supplied to the DCI together with the report. He relied on the report from the Communications Authority of Kenya to proceed and charge the accused person. The probative value of PW1's testimony was considerably diminished under cross-examination. He candidly admitted that he did not play the video in court, and that he could not authenticate it, that he was not an expert in forensic and artificial intelligence. He conceded that there existed AI-generated videos capable of manipulating images and voices. He also admitted that he could not tell who captured the video or who uploaded it. He conceded that he could not confirm that the TikTok and the YouTube accounts in question were controlled by the accused person. He also acknowledged that the accused person is a political activist and that the arrests occurred during a period of nationwide demonstration related to the finance bill, a context within which political expression was widespread. He further admitted that he did not know whether the video constituted political expression. This concession significantly weakened the evidentiary link between the accused and the alleged publication, as well as the authenticity and reliability of the impugned content. PW2's statement, who is the arresting officer, his evidence was limited to the fact of arrest only. He stated that he does not have materially advanced proof of publication, authorship, control, and unlawful provision of telecommunication services. PW3, who is the digital forensic analyst seconded to the Kenya Communications Authority of Kenya, admitted that the author of the said video was Ribanius and not the accused person. He also stated that he never received any graduates for examination, which was contrary to what the investigating officer stated, that the said phone was presented to them for analysis. He also stated and accepted that there was a margin of error in the tools used for the said analysis. The first critical element under Section 23 is publication. In the context of cybercrime, publication entails more than mere presence in content. It requires proof that the accused person authored, uploaded, disseminated, controlled, or had responsibility for offending material. The prosecution was therefore required to demonstrate digital linkage between the accused person and the impugned accounts through evidence such as account registration details, IP addresses, subscriber information, device analysis, or corroborative electronic trails. In the present case, there was no such nexus that had been established. PW1 admitted that he could not authenticate the video to the accused's devices or the accounts. The second element is falsity of the information. The prosecution did not tender any evidence demonstrating that the statements in question were false. No investigation was presented to establish that the alleged statements had no basis in fact or that they were fabrications. I have looked at a case of Geoffrey Andere versus Attorney General 2016, EKLR. High Court underscored the criminal liability for false information requires proof of falsity and malicious intent, and that the vague or unverified assertions cannot suffice. The third element is knowledge of falsity and recklessness. Even assuming publication and falsity were proved, the prosecution must demonstrate that the accused person knew the information was false or was reckless as to its truth. No such evidence was adduced. The accused's state of mind was not demonstrated through any direct or circumstantial evidence. The fourth element is that the publication was likely to cause panic, chaos, violence, or damage to the reputation. While the subject matter of the alleged statements is undoubtedly grave, the prosecution did not tender any evidence showing that panic, chaos, or violence occurred or was imminent as a result of the alleged publication. In relation to count number 3, brought under Section 24 of the Kenya Information and Communication Act, the same criminalizes the provision of telecommunication services without a license. The prosecution did not demonstrate that the accused person provided telecommunication services as defined under the Act. No evidence was adduced that the accused person operated transmission infrastructure, broadcasting services, server or signal distribution system. Merely using social media platform or appearing in online videos does not constitute provision of telecommunication services requiring a license. This position is affirmed in Republic versus Blog Associations of Kenya, that is for 2018, EKLR, where the court observed that individual content creators on social media platforms are not per se telecommunication service providers within the meaning of the Act. On electronic evidence and the law, the court must consider admissibility and sufficiency of electronic evidence. Section 106B of the Evidence Act governs admissibility of electronic evidence and requires certification and proof of integrity of the system, while the prosecution produced a CD and reports the chain of custody, integrity of the extraction, and linkage to the accused person were not adequately demonstrated. The case of Republic versus Barisa Wayu Matuguda, 2011, EKLR. The court stressed that electronic evidence must be handled with particular caution due to its susceptibility to manipulation. The concessions made by PW1 and PW3 regarding potential AI manipulation and errors further weaken the reliability of the electronic evidence. On whether there is a prima facie case which has been established, upon anxious consideration of all the evidence and the applicable law, this court finds that the prosecution has failed to establish a prima facie case against the accused person in respect to all the three counts. The prosecution has not demonstrated publication by the accused person, falsity, knowledge, or reckless disregard of truth, or it has established, nor has it established the provision of telecommunication services without a license. What emerges is, at best, suspicion and a conjecture which was held in Sawe versus Republic, which cannot form the basis of a criminal conviction. Therefore, pursuant to Section 210 of the Criminal Procedure Code, this court finds that the accused person, Nuru Okanga Maloba, has no case to answer, is hereby acquitted of all the three counts, and shall be set free forthwith unless lawfully held.
Most obliged.
Most obliged.
Most obliged. Your Honor, we welcome the wise ruling of this honorable court, which affirms the principles of fairness, justice, and due process. Your Honor, we appreciate the court's careful consideration of the facts and the law in upholding the rights of the accused person, one Mr. Nuru Okanga. And Your Honor, may God bless you always for upholding the rule of law. Thank you. Please, Your Honor, we will go home and sleep. We've been praying for Nuru Okanga because we didn't know what could come next. Thank you, Your Honor.
Your Honor, the Okanga Commission, Minister Abnaman. Apologies, I walked in a bit late. But just to join my colleagues and the entire team in thanking the court for its ruling and upholding the rule of law. We do pray for typed copy of this ruling because it has the potential of setting similar precedents, because this is one of many frivolous charges of people being arraigned in court under the Computer Misuse and Cyber Crimes Act. We shall still be appearing before Justice Mugambi on the 5th of February to highlight our submissions on the propriety of the said act. My colleague, Mr. Wino, is part of the petition. Just to send a personal thank you note from our client, Mr. Nuru Okanga. He is grateful and thankful to the court and prays that the cash bill that had been deposited be refunded to the depositor. Oh, sorry. Sorry, Mr. Wamboi has had cash bill. I decided to step in, so I hand over to him. Thank you.
Your Honor, thank you. Your Honor, I have at least some institutional memory as to how far we've gone with this matter. Previously, the court will note, we had an issue with the cash bill that had been deposited by a certain lady. Your Honor will recall that we reimbursed some of the monies that were deposited on behalf of the accused person in the presence of the depositor. The court took notice that the cash bill that had been deposited as security for the release of the accused would, at the very tail end of the matter, be remitted to the accused. Not to myself. Your Honor, as I pray that the order you had initially made be reaffirmed, that the money be deposited or be remitted back to the accused, I must equally join my colleagues in thanking most sincerely the Honorable Court, not only for the Solomonic decision that the court has made, but equally for the expediency through which this court has had to hear and determine the issues that were in controversy. More to it, Your Honor, I must acknowledge that justice has been served. The angels in heaven are singing. So, down here on earth, we shall be dancing in celebration of the verdict by this honorable court. Your Honor, on my part, as an ardent constitutional student, I must take notice that the decision that this court has made, especially in relation to Nuru Okanga and the Cybercrimes Act, is one that sends a very strong message to our law enforcement officers. But it is not enough just to arrest someone, detain him for 3 weeks, present him before an honorable court, waste the prosecution's time and the resources of the great people of the Republic of Kenya, only for us to arrive at a conclusion that indeed there was more than what meets the eye. I shall be taking instructions, of course, jointly with my colleagues who have been with me in this line of battle, so that, Your Honor, our client can guide us as to whether we will be seeking for compensation from the state for the false charges that were levied against our client, the time that he has had to spend in police custody. There was a miscellaneous application in this matter. My client, who is a student, has been facing a lot of challenges, being in class and sometimes being victimized as a criminal. Your Honor, I think in the circumstances as arrest, the best way of telling our client, Paul, will be in prosecuting zealously an application against the state so that we can give him certain compensation. With some few millions, Your Honor, he might answer. Thank you, Your Honor. We are most obliged.
Your Honor, I also want to just join my colleagues in sincerely thanking you for the patience that you exhibited during the hearing of this matter. I remember even when you requested for 2 hours, you still granted it and sat for a long time just in quest for truth and justice for Nuru Okanga. We sincerely thank you, and may God bless you and your village.
Yes, Your Honor, on the part of the prosecution, we've had the ruling. I do appreciate it. We'll be praying for a copy of the certified copy of the ruling. And I've heard my colleagues' sentiments. I think to go on record, no one has thanked me for present proceedings, but our work is not to be thanked by members of the public, but we do appreciate that that they acknowledge that I was there. Your Honor, further to that, I've heard that there is, we require the said ruling so that we can be able to digest the same, as we've heard that there are other proceedings before Justice Mugambi. And probably I'll have a conversation with my colleagues outside court precincts and advise them not to use this ruling as a precedent because there's a hierarchy of courts. So finally, Your Honor, we do also appreciate the court on how it has conducted itself. I don't think the accused person has any qualms with us. We've accommodated him numerous times, and even had to put this matter in the so-called school holidays when schools were closed. That's why it probably took quite a time. But in conclusion, let me reiterate that this was not a waste of time. If the accused person feels that justice has been served to him, definitely it's not a waste of time. And it's not necessarily that all matters must end into convictions. Sometimes they are acquittals, but we are not saying that we have ceded ground that we will not pursue this matter further. Thank you.
You know, Mr. Kiragu seems to be in a very good mood today. We will buy him tea.
General Member.
Mr. Nuru Okanga,
Yes.
you have anything to say?
I'm going to use Kiswahili because I'm not understanding English very well. Mimi nataka nishukuru Senior Counsel, na pia nataka nishukuru wewe ambao umekalia hiyo mtihani. Ama nataka nishukuru Yona kwa kufanya uamuzi ambao imefurahisha roho yangu na kwa kufanya uamuzi ambao imefurahisha Raila Amolo Odinga mahali hapa. Sababu hizi kesi zote zilishikwa kwa sababu ya baba. Na pia mahali baba ametuacha na hapo na ameona umefanya uamuzi. Mungu abariki familia yako. Mungu abariki vijukuu zako. Mungu akuondolee magonjwa. Slip yako ijaze isikaze. Nitazidi kupigania Kenya, nitazidi kusimama imara, nikiongea sana nitaharibu. Asante sana na Mungu akubariki.
Thank you so much. I think also for your patience. It has taken time, but I want to thank you. The work of the prosecutor is to present a case the way it is, not necessarily to ensure that someone is jailed or found guilty. So I want to appreciate you. Let us uphold the rule of law. And once again, thank you.
Mr. Yona, 1 second.
I hope you'll not be back here again.
1 second. Nilikuwa nimesahau Mr. Yona. Vile wakili amesema kuna pesa zangu ziko huko. Na sasa ni Januari unajua. Niko na watoto pia, mimi ni mwanafunzi. So ni jukumu yako kuandika barua iende, at least hiyo cash bill itoka haraka nilipe school fees ya watoto, pia nikilipie mimi, pia nilipe rent. Na mambo itaenda sawa sawa. Kwa big respect.
Cash bail to be released to the accused person.
Most obliged.
Good day.